Hello.
Okay. All right, so calling case number 22-00618, People versus Podashinsky.
Good morning, Kyle Peskovich, appearing on behalf of people.
Morning, Judge Barton Morris, appearing on behalf and with Mr. Podashinsky.
Mr. Podashinsky, state your name. Mr. Podashinsky,
Yes, sir.
state your name.
Yes, sir. Stanislav Podashinsky. Good morning, Your Honor.
Today's date and time set for a probable cause conference. Mr. Morris, do you need to speak with the prosecutor on this?
No, he just sent me the discovery this morning, and so I'm asking for another probable cause conference next week.
All right, well, so let's walk through this real quick. I just want to bring you up to speed.
Yeah.
So Mr. Podashinsky has been set for exam multiple times, has failed to appear multiple times. He's been ordered to do drug and alcohol testing and has never been in full compliance, never been in like bare minimum compliance. I indicated to the magistrate that he's to be, if he is apprehended or even turns himself in, a high cash bond needed to be set to secure his appearance. I recommended a minimum 75,000 cash surety, no 10%. And on a charge like this, Mr. Morris, you know me well enough to know that's a bond that I would never set on charges like this, but for the fact that Mr. Podashinsky is completely unreliable when it comes to appearing for court and has little to no respect for this court, as demonstrated by his conduct throughout the lengthy time that this matter has been in this court. It looks to me as if the magistrate gave him an opportunity to be on a lower bond than that, 75,000 cash surety or 10%. Of course, we give our magistrates wide discretion. And so there may have been something that came up during that period of time. Probably your presence, Mr. Morris, saved the day as far as the high nature of the bond. But what I've seen already, now he was released from OCJ 3 days ago. On August 15th, defendant was released from Oakland County Jail. This is the report I have from pretrial services. And you may not have gotten this yet, Mr. Morris, so I don't expect you to be fully prepared for it. But I want to make sure you know the details. Defendant was released from the Oakland County Jail with the GPS tether. Pretrial supervision tether unit completed the enrollment phone call on 8/16. At that time, defendant was made aware of all bond conditions. Defendant was given the information to check in with pretrial services and instructed to make the first call the same afternoon and then call every Thursday afterwards. He was released from the Oakland County Jail on August 15th with the GPS tether. Defendant was instructed to go straight home and not make any stops. Defendant failed to comply, stopping at Henry Ford West Bloomfield Hospital. This is kind of what I've become used to with Mr. Podashinsky. I set bond conditions. He follows his own set of bond conditions. My expectation is that he will not be in compliance with this bond. I'm hoping, Mr. Morris, with your long track record of success, even with those clients who have presented difficulties in understanding that their liberty is constantly at stake when it comes to being on bond, and you have had success in reining individuals in and helping them know that the worse they do on bond, the more difficult it makes your life. But what confidence should I take in any hope of expectation that Mr. Podashinsky will show up to court like he's supposed to, do his testing like he's supposed to, and follow the tether requirements like he's supposed to?
Thank you for giving me the opportunity to address those very important issues. And thank you for recognizing my prior some success in dealing with these situations. First of all, Mr. Podashinsky did turn himself in voluntarily. He contacted me in my office and made arrangements to do that, knowing that he was going to be taken in custody and given a bond or a high bond. his father is who is posting the bond and who had very significant reservations about posting this bond because of the history. But Mr. Podoshinsky is on a methadone. He's getting methadone treatments, and he wasn't getting them in the jail. And his father was very concerned about. Oh yeah, his father was concerned about his health and safety. Mr. Podoshinsky has agreed to attend meetings every day. I would like the court to add that as a bond condition. Of course, continue to test. I am going to check in with him regularly every single week to ensure that he's attending meetings every day and he's testing. His father, he's living now with his father. I didn't know he was ordered. I didn't know what his other conditions were as far as being ordered to go straight home. And I don't know why he went to the hospital, but maybe it had something to do with him getting a methadone treatment, because I know that that's probably the first thing that he was thinking about doing when he was released. Perhaps he can answer that. But other than that, I appreciate everything the courts had to say. I only wanted 1 week adjournment in order to try to move this along and to limit the opportunities for non-compliance. But I will tell this court that I will personally involve myself to the degree to which I believe is necessary in order to, and obviously there's only so much that I can do, but he's out, and I want, and he wants, and his father wants him to maintain compliance. He's tested, I guess, negatively yesterday, except for the methadone. He will continue to test as far as I'm involved. He's gonna be required to test. I'm gonna be checking on it, and I want him to attend meetings every single day, if that's not already a requirement of the bond.
All right, I will add that as part of the bond. He is
Your
to,
Honor,
yes, Mr. Veskovich.
what do you have in terms of the defendant testing since released? Because on my end, I'm just seeing failure to appear for drug and ETG test on August 16th. I don't have anything after that point.
I don't have, he was supposed to test on the 16th. I didn't receive information that he did or didn't test on the 16th. So
I have a August 17th entry saying that he failed to post testing at EverHealth.
So Mr. Podoshinsky is holding up what appears to be some type of receipt. I don't know. I'm guessing that he may have tested at the hospital. That does not.
What does that say?
There is a Medcar urgent care. I tested there on the 16th at 8:45 p.m. Because there was no way I could get, it was only one vehicle, and I was unfortunately I wasn't able to get to EverHealth that day. So I would make sure that I would test that day because of the conditions of the court. So I went and got a test. I will make a copy of this and send it over to the pretrial services so they will have it on record.
Okay, so Mr. Morris, this is what we run into. Again, it's a situation where Mr. Podoshinsky is going in at 8:45 at night. I don't know what he's doing the rest of the day. He's on a tether. He shouldn't. There should be no other activities other than he working on his sobriety. And so I don't know why. And perhaps you'll be able to dig into this. If you can get a copy of that testing at urgent care is not sufficient. All right, that's not going to cover him going forward. He's going to need to be working with pretrial services. Mr. Morris, Mr. Podoshinsky, I've heard plenty of words from you. All right, what I haven't seen is any kind of action in any sort of productive. No,
apologize,
Mr. Podoshinsky, let Mr. Morris do the talking for you. All right, and my best advice to you is when he tells you to do something, all right, you do it. All right, you don't do it in the way you want to do it. You don't go, if he tells you to go test at EverHealth, don't go to urgent care. If he tells you to go to a meeting in person, don't go to one in Zoom. If he tells you to stay, at your house, don't go out and walk around the neighborhood. Follow the rules, all right, that the court has set forth, and the advice that Mr. Morris is going to give you. I mean, Mr. Morris, the only hope that I have that he will be in compliance is you. And I don't mean to say it in a way that puts extra weight on you. It's just that I know that you can guide and direct and maybe point out some things that he didn't get before. And so I'm not saying that I expect you to guarantee compliance. What I am expecting, though, is that our best chance at him understanding the need for compliance is basically his connection with you. So that's, again, I want to make sure I'm not putting it all on you, Mr.
I
Morris.
understand
I'm
completely.
just
Your
saying,
Honor.
like, we got a chance here because I think you'll be able to reinforce. One, I'm going to zealously advocate for you. I'm going to fight for you, but I'm not going to suffer, this type of conduct. So I will adjourn this 1 week. He's to go to daily meetings. He's to drug test every other day. If he wants to do anything outside of what he's allowed to do on tether, he needs to call you first, and then you just reach out to the court and let me know. So if he needs to, if something having to do with his treatment or requires him to go to the hospital, obviously if it's an urgent matter, I'm not saying that he can't go to the hospital if he is suffering a major health issue. All right, but if he just wants to stop by or meet with the treatment or do something, he needs to check with you first. So, all right, I'll see you in a week. It'll be at 1:31 p.m. We have an afternoon docket next week.
I like those meetings in person, Your Honor.
In-person meetings, yes.
Your Honor, may I address the court?
Nope. At this point in time, I don't think it's a good idea because you have an attorney. Talk to your attorney first, and then you can speak to the court. All right. It's not that I'm trying to shut down your voice. It's just that in my experience, when you talk, you often get yourself in trouble.
That's a good idea.
I'll call you, Steve, right now.
Thank you, Mr. Morris.
Thank you, Your Honor.
Thank you, Your Honor. Thank you for another chance.